I just finished reading the reply brief that Lively filed in the 47.1 motion, and I'm just like, what? You know when you read something and you're like, I don't think I was paying attention. Let me go back and read it. And you read it again, you're like, I didn't understand what I was reading. So you read it again. I feel like that's how this reply brief went for me. It was like a bunch of legal sentences smushed together. Like it didn't have coherence. There was something kind of off about it. What they try to do here is they take Wayfarer's arguments and try to break them apart in some way. But I don't actually think they did a very effective job at that. The first argument about whether or not constitutional rights are being affected is kind of like a nuh-uh, no. Like you court, you can decide on this if you want to. Those cases that they referred to, it doesn't actually say what they wanted to say. So, there might be an opportunity for you to do this if you really wanted to. The first argument is just not clear. Next, they address the extraterritoriality argument. And they were like, it doesn't matter that she's not a resident of California because Wayfarer chose to file their lawsuit under California law. So Lively should get protection because Wayfarer's in California and they acted under California law. They make this public policy argument that, the California legislature enacted 47.1 to protect victims of SA, and discrimination and ensure that perpetrators don't misuse litigation. Okay, but they don't talk about the legislature's intent of how far this law is intended to reach. So anytime anyone in the United States makes some kind of statement and then gets sued for defamation from a California person, does this law apply? They don't really go into that legislative history of what was the real intent behind the law, who was it intended to protect, and kind of gloss over the presumption that the laws that are in place in California are intended to protect the residents of California. They're viewing the law as a sort of a punishing thing. Like, this is how we punish a California resident who's done wrong. Instead of, this law is meant to protect, and this is how it's intended to protect. And it might seem nuanced, but it's important. What was the legislature's intent? This was the time to say it. You're asking the court to interpret legislation. So this was the time to show how to interpret it. Next, what I can only interpret as just discombobulating people is this discussion about the malice piece. The malice piece is in the statute. It says that you don't get a privilege when you say something with malice. Theretofore, you have to say it without malice, so it has to be proven that it was said without malice. So I don't know why they go on this discussion about how her claims, the defamation claims didn't say anything about malice, because that's not really what the inquiry is about. The inquiry is about whether Lively made these claims about SH, discrimination, etc., if she made those claims without malice. Because if she did it with malice, there's no privilege, and 47.1 goes away. And I think they recognize the flaw in this because they try to refer to something that was put in the complaint about how, I guess, Baldoni and Nathan, there was a text exchange where somebody said they think that Lively genuinely believes that she's right. They quoted that. So they're quoting, something as evidence to support the fact that the statements were not made with malice. But you're begging an evidentiary hearing. You're asking for the judge to do an evidentiary hearing, which is exactly what the Wayfarer party said, and you're not addressing. They did not address why the court should not engage in an evidentiary hearing. They do want an evidentiary hearing with respect to treble damages, though. So, yeah. They don't address how this could lead to inconsistent rulings. They don't address why it needs to be done now, other than to say, you, judge, can do it if you want to. You should, because you should. I mean, it just doesn't say why it needs to be decided now. And this was the time for them to say that. This was the time for them to tell the judge why it needed to be decided now, as opposed to what he's likely to do, which is kick the can and do it after trial.